and thank you for joining us for our annual immigration webinar. It's been quite a year with lots of changes in the immigration space, and there's more to come. Today, we'll take you through what's happened so far this year, what we expect to see on the horizon, and even some thoughts on what 2026 and beyond might look like. So before we start with the content, let me take you through some of our housekeeping points. The webinar has been held remotely, so please do bear with us should we experience any technical difficulties. We will aim to resolve these as quickly as we can. Our webinar today will be 1 hour long. That's 45 minutes of presentation with 15 minutes at the end to answer your questions, which I'm sure there will be lots of. All attendees are on mute throughout the course of the presentation. If you have any questions, please add them into the questions box, and we will endeavour to answer as many as we can at the end of our presentation. Any we cannot answer on the webinar, we will follow up in an email afterwards. As usual, there will be some polls throughout the webinar, so please do get involved with these, as it really makes it a little bit more interactive. Our webinar is being recorded, and we will send the recording to all attendees later today. And finally, at the end of our webinar, in usual style, we will have a survey to find out how you found the content and how we can improve topics for future presentations. Your feedback will help us with the planning of future events. And as a thank you for your feedback, those who complete it will be entered into a prize draw for our £50 John Lewis voucher, which will be helpful for Christmas shopping. So the speakers today, I'm Imelda Reddington, Partner and Head of Immigration at Consumer Parks, and I will be joined today by Callum De Freitas, who is an Associate in the Employment and Immigration team. So what will we look at today? So firstly, I will look at the compliance and enforcement action from the Home Office. I will then hand you over to Callum, who will take a look at what's been implemented from the white paper followed from our seminar earlier this year. Callum will then also discuss the most recent bombshell on indefinite leave to remain proposals and the consultation guidelines, which were published last Thursday. Callum will also then look at the proposed expansion for right to work and digital move, expansion of the scope for casual workers and gig economy workers, and then back to me to talk about travel authorizations, ETA, ETIS, etc. And then finally, Callum will look ahead to 2026 and beyond. So our first topic, let's look at the compliance and enforcement. We are seeing a continued trend of enforcement actions targeting business and sponsors for illegal working. This crackdown reflects the Home Office's intensified focus on compliance. We look at these developments a little bit more detail, including enforcement measures, sponsor license actions, sector-specific risks, and finally some practical steps that employers should take to stay compliant. Now moving on to compliance visits and arrests. The UK Home Office have significantly increased its enforcement activity to combat illegal working. In January 2025, 828 premises were visited. That represents a 48% rise compared to January 2024. Arrests during these visits also surged by 73%, highlighting the government's intensified focus on compliance. The escalation is part of a broader strategy to deter illegal employment and to ensure employers adhere to employment law, immigration law. Employers should anticipate more frequent and unannounced visits, making it critical really to maintain accurate records and robust compliance systems. The increase in enforcement resources included the deployment of an additional 1,000 officers, so it does demonstrate the seriousness of the Home Office crackdown. And businesses that fail to comply will risk severe penalties, reputational damage, and of course operational disruption. And moving on to the fines too, civil penalty notices and financial risks. Between July 2024 and January 2025, the Home Office issued over 1,000 civil penalty notices to employers found liable for illegal working. Now, since earlier in the year, fines reached up to £27 £60,000 per employer. That's up from 20,000 per worker. That represents a substantial financial risk for non-compliant businesses. The surge in penalties reflects the zero tolerance approach and the Home Office's commitment to enforcing immigration laws vigorously. Employers must implement proactive measures such as regular internal audits, accurate payroll management, and of course the verification of their employees using the Home Office approved digital tools. Failing to comply not only results in these financial penalties, but also exposes the business again to reputational harm and potential sponsor license revocation for sponsors. So let us first move on to our first poll. This is just to get an idea of our audience. So if you could share with me who in attendance on this webinar is a registered sponsor. We have three options. We have a sponsor license, we do not have a sponsor license, or we are in the process of applying or have applied previously. Okay, so we have 62% who have a sponsor license. So the next piece of information will be quite useful for you. Thank you very much for your participation. So let us look now at the rising refusal rates. So sponsor license applications have recently faced unprecedented scrutiny, with refusal rates climbing sharply. In the quarter from July to September 2024, nearly 40% of applications were unsuccessful. Now compare this to the previous 3-year average, which we saw between 20 and 25% unsuccessful rates. This trend is continuing, and by the end of June 2025, refusal rates reached approximately 44%. That's almost half of all licenses are either been refused or rejected. Now, the increase is attributed to stricter interpretations of the eligibility criteria, particularly the requirement for businesses to demonstrate they're active in trading. Employers seeking to sponsor skilled workers must ensure that documentation is comprehensive and accurate, and that they maintain compliance with all Home Office sponsorship duties and requirements. Failing to meet these standards can result in an application rejection or, in fact, hinder your workforce planning. So looking now at the license revocations, sponsor license revocations have reached record levels, with almost 2,000 licenses revoked between July 2024 and June 2025. That's more than double the previous year's figure. This surge reflects the Home Office's intensified focus on sponsor compliance in its effort to stop the abuse of the immigration system. Now, common reasons for revocation include underpayment of migrant workers, exploitation, failing to meet reporting obligations, and for some high-risk sectors such as adult social care, hospitality, retail and construction. These have all been particularly affected. Employers should be prioritising compliance training, maintaining accurate records, and implementing a robust monitoring system to avoid any consequences of non-compliance. So looking at a little bit more detail of the high-risk industries, enforcement activity has disproportionately targeted certain sectors, with restaurants, takeaways and cafes accounting for a significant share of the compliance visits. So the food, drink, tobacco industries, along with adult social care, hospitality, retail and construction, have also been identified as high-risk areas. These sectors often rely on migrant labour and do make them more vulnerable to compliance breaches. So if you are in those sectors, it's particularly important to maintain all of this sponsorship duties and reporting obligations. Let's move on to look at the enforcement trends. Illegal working visits have remained consistently high through 2025, with almost 5,500 visits in Q1, rising to almost 6,000 visits in both Q2 and 3. And this sustained level of enforcement indicates that compliance checks are not seasonal, they're ongoing. Employers should maintain continuous vigilance and avoid complacency. Regular internal reviews, accurate record keeping, and keeping up to date with the Home Office guidance are essential to mitigating risk. The Home Office commitment to maintaining high enforcement levels suggests that businesses must treat compliance as a core operational priority rather than an occasional task. So how can employers ensure compliance? Employers should take immediate steps to strengthen their frameworks. Key actions include adopting the Home Office approved digital identity verification tools if you haven't done so already, conduct internal audits and training against your HR teams on sponsor license duties and reporting obligations. Payroll and tax records must align with immigration data to avoid triggering investigations. We now know that HMRC and the Home Office share information. Business should prepare for unannounced Home Office visits by maintaining accurate and accessible documentation. Now, by implementing these measures, employers can reduce the risk of penalties, license revocations, and reputational harm. Enforcement activity remains strong, with financial penalties continuing to be the most common sanction for employers who fail to comply with immigration requirements. So I'm now going to look at another poll before I have a look in detail at the figures reported so far this year. So given the increased level of compliance and penalties enforced, what do you think was the highest level of financial penalties issued in one quarter of 2025? Is it 28.3 million? Is it 2.5 million? Or is it 41.6 million? That's interesting. So 67% have said 28.3 million, 13% have said 2.5 million, and 21% are 41.6 million. Okay, so I'll move on to our next slide, which shares with you the civil penalty statistics. The chart shows illegal worker penalties by volume, value, and average from 2023 to 2025. The orange bars are the volumes of fines in hundreds, and the yellow line denotes the total amount of penalties in millions, showing a steady increase since 2023. It's peaked at 41.6 million, so we had over 20% of our attendees who got that right in quarter one of 2025. But in the last quarter of reported figures, we saw it drop to 28.3 million, so 60% of our attendees got that number correct. The green line shows the average penalty amount, which rose sharply from 11,000 per penalty in quarter 4 of 2023 to 32,000 in quarter 1 of 2024. Now that reflects the tripling of the fines from 20,000 to 60,000 in February 2024. So while the number of penalties fluctuate across the orange bars, we do see the average penalty from quarter 3 2024 at 50,000, rising to 60,000 in Q4 24, then dropping slightly. So we are seeing the average penalty issued between 50 and 60,000. And we have yet to see the figures from quarter 3 and 4 of 2025. We normally see quarter 3 figures issued at the end of the year or the beginning of the next year. So we wait to see if this trend continues. So in the first 6 months of 2025, there were almost £70 million of fines issued, with one business receiving a single fine in excess of £300,000. So in order to avoid these hefty fines, it is important that you carry out right-to-work checks in the correct way. Callum will cover this in a little bit more detail later. And now, speaking of Callum, I'm about to hand over to you. He will talk a little bit more about the white paper changes, the earned settlement proposals, and of course the right-to-work consultations. Over to you, Callum.
Thank you, Imelda. One of the big stories of 2025 was the immigration white paper, published in May of this year, which set out the government's plans to overhaul the UK immigration system. Now, we hosted a webinar on the white paper shortly after its publication, which I'm sure some of you will remember. If you want a more complete rundown of the white paper's proposals and their expected impact on employers, then I would suggest watching the recording of that webinar, which is available on our website. But in summary, the big policy proposals from the white paper were to raise the minimum skill level for jobs on the skilled worker visa, making many roles ineligible for the route, to increase the minimum salary requirements for the skilled worker visa, to increase the immigration skills charge, which is paid by employers when sponsoring skilled workers, to introduce higher standards for English language for all visas, to reduce the length of the graduate visa from 24 months to 18 months, and perhaps most infamously, changes to indefinite leave to remain, which would see the qualifying period for settlement increased from 5 years to 10 years. It's now been 6 months since the government announced these proposals, and so it's worth considering what progress has been made on these, which proposals have already been implemented, which are in the pipeline, and which have been put on the back burner. And that's what we'll move on to look at now. Many changes to the skilled worker visa were brought into effect on the 22nd of July 2025, with the general minimum salary threshold increasing from 38,700 to 41,700 per year, with corresponding increases to the going rate salary thresholds for many occupation codes. Now, it should be noted that these salary threshold changes were introduced subject to transitional provisions, meaning that those who had their first skilled worker certificate of sponsorship assigned before April 2024 were not subject to the new higher rates. However, these transitional provisions have made the salary requirements far more complicated than they were previously, with multiple sets of rules to refer to and an increased number of considerations to factor in. As a result, there is now a higher risk of employers getting caught out and inadvertently underpaying their skilled workers. At the same time, the Home Office increased the minimum skill level roles to RQF 6, equivalent to a bachelor's degree. As a result, over 100 occupation codes, which fall below the new skill threshold, became ineligible for standard skilled worker visas. These included roles like lab technicians, IT workers, some data analysts, some sales staff, and healthcare and public service professionals. Now, some of these roles were moved onto the new temporary shortage list, which is intended to cover those roles which fall below RQF 6, but which are still seen as essential to UK industry. However, workers on the temporary shortage list are subject to onerous restrictions, such as being unable to bring family members or utilise any of the normal salary and visa fee discounts. Now, while the temporary shortage list currently has over 50 occupation codes on it, the Migration Advisory Committee are in the process of reviewing this, and the available roles are likely to change next year. We understand from conversations that we've had with clients and contacts that these changes to salary thresholds and skill levels have had a significant inflationary impact on wages for many employers, much as we predicted in our white paper webinar. A skilled worker salary has now become unaffordable for some roles, while a reduced supply of labour for those roles that are no longer eligible for skilled worker visas has also had an inflationary effect and made recruitment more difficult. And there are going to be further cost increases when the immigration skills charge goes up in December. The skills charge is a fee that employers normally have to pay when sponsoring workers on the skilled worker route, and it's paid upfront as a lump sum. From the 16th of December 2025, this fee will increase by 32% across the board. For a 5-year visa, a small company will now pay a total skills charge of £2,400 instead of £1,820. And for a medium or large company, the total charge will increase from £5,000 to £6,600. Now, this change will only affect certificate of sponsorship from the 16th of December 2025 onwards. So if you assign a certificate of sponsorship before the 16th of December, you'll pay the current lower rate of skills charge, even if the visa application is not approved or even submitted until after the 16th of December. And therefore, if you have a candidate or an existing employee who is going to apply for a skilled worker visa in December of this year or early 2026, we would recommend that you consider assigning the certificate of sponsorship to them before the 16th of December to take advantage of the lower fees, even if they're not ready to submit their visa application just yet. You can assign a certificate of sponsorship up to 3 months before the visa application needs to be submitted. So provided the employee submits their visa application by that time, you'll be fine. Moving on, the detail on the changing English language requirements has also been announced. From the 8th of January 2026, the English language requirements for the skilled worker, high potential individual and scale-up visas will increase from the current CEFA B1 level to B2 level, which is meant to be equivalent to A-level standard. This means that lead applicants applying for these visas on or after the 8th of January 2026 will need to pass an approved English language test in speaking, reading, listening and writing at B2 level, unless they are a national of an English-speaking country. Now, to be clear, this change will not affect those who are seeking to extend their existing visas. But if someone were to switch their visa on or after the 8th of January 2026, for example, if someone were switching from a high potential individual visa to a skilled worker visa, then they would be caught by the new requirements and would need to demonstrate English language at B2 level. Now, for the time being, no English language requirement has been announced for dependent family members, despite this being proposed in the white paper. And perhaps we can expect to see more on this later in 2026. As anticipated, the length of stay on the graduate visa is being reduced from 24 months to 18 months. Now, for those of you who aren't aware, the graduate visa is a visa that becomes available after someone on a student visa completes their studies, allowing them to live and work in the UK. This change to the length of stay will affect all those who apply for their graduate visa on or after the 1st of January 2027. In practice, this means that the current cohort of students in the final year of their studies will be unaffected by this change. Now, the Home Office have said that the reason for this change is to encourage graduates to find high-skilled employment sooner, but it will also mean that employers will have less time to make decisions regarding the retention of their employees who are on graduate visas. Interestingly, the high potential individual visa, which is available to those who have graduated from a world-leading international university, has retained its 24-month length of stay. And the Home Office is also doubling the number of eligible institutions, meaning the universities that applicants can have graduated from in order to be eligible for this visa. And that greatly widens the scope of potential applicants. Perhaps unintentionally, these changes together are likely to result in some of the best international students choosing to attend a university abroad rather than study in the UK, and then apply for a high potential individual visa, as they can stay on this visa for an additional 6 months compared to the graduate visa. This is, of course, likely to have a knock-on impact on the income of British universities. And then, of course, there are the changes to indefinite leave to remain, or ILR, also known as settlement. Now, last week I had prepared to say that there was still a significant lack of clarity around the proposed changes to ILR, but that all changed on Thursday when the Home Office published a consultation statement setting out their proposals in more detail. We'll move on to look at that now. Now, before going any further, I should say that all of this is subject to consultation and nothing is set in stone just yet. But the statement did include two big pieces of news. Firstly, the standard qualifying period for ILR will increase from 5 years to 10 years, much as anticipated. And secondly, this will apply retroactively. So anyone who has not got ILR in the UK, but by the time the changes come into force, is expected to be subject to the new rules. However, the statement also clarifies that it will be possible to qualify in under 10 years in certain circumstances. Firstly, if someone has earned annual taxable income of £50,270 or more for the 3 years immediately prior to applying for settlement, then they can qualify for settlement after 5 years in the UK, as under the current rules. And if they've earned annual taxable income of £125,140 for the 3 years immediately prior to applying for settlement, then they can qualify for settlement after just 3 years in the UK. Now, in light of these reductions, there may be circumstances in which it makes sense for employers to give their sponsored employees a slight bump in salary, just to push them over one of these thresholds and allow them to settle sooner, as that will mean that the employer does not have to pay immigration costs, nor comply with their sponsorship duties for as many years. It's also proposed that an applicant who has worked in their local community, for example, volunteering, will be able to settle after 5 to 7 years, and that those working in certain public service roles will qualify after 5 years of working in such roles, though the detail on how these options will work in practice is subject to consultation. And it will also be possible to qualify for settlement on a slightly shorter pathway of 9 years if the applicant passes an approved English language test at CEFA level C1. Now, it's not clear from the statement whether those from English-speaking countries, such as Australia, Canada, and the US, would automatically qualify for the 9-year route by virtue of their nationality, or have to take a C1 level test themselves. Moving on, it's important to note that even if the main applicant qualifies for a faster route to settlement, the current proposal is that any adult family members would be assessed on their own merits. So the mere fact that the main applicant is eligible to qualify after just 3 or 5 years, for example, wouldn't necessarily mean that the same would be true for their spouse or partner. In respect of children, it's proposed that children who are aged under 18 when their parent qualifies for settlement will be eligible to settle at the same time. But the position is slightly less clear for children who will be aged 18 or over at that time. Now, in some circumstances, the qualifying period may even be longer than 10 years, where an applicant has been in receipt of public funds or in breach of immigration rules, for example. Indeed, the Home Office are even considering setting the standard qualifying period at 15 years for those who are in roles at a skill level below RQF 6, though it is unclear how this would work in practice. For example, if someone had been on a medium skilled role for a few years, but then switched to an RQF 6 role, what qualifying period would apply? For the time being, the proposals aren't clear on this. Now, these new rules won't apply to everyone. There are some exceptions. Family members of British nationals will continue to qualify after 5 years, and visas like the Global Talent and Innovator Founder route will be unaffected. Similarly, these changes to ILR do not affect those who have pre-settled status under the EU settlement scheme, as their rights are protected under the EU withdrawal agreement. We've got another poll for you now, and this is just to get your initial thoughts on these proposed changes to settlement. So, what are your thoughts? Do you think that these proposals are well thought through? They'll have a generally positive impact? Do you think that they're generally good? There are some exceptions allowing for quick settlement, that's good, but applying these changes retroactively is unfair? Do you think that they made it far too complicated now that people won't understand when they're entitled to settle? Or do you think that the changes are terrible and you disagree with increasing the qualifying period whatsoever? So I understand that these might not fit exactly with how you're feeling or what you think, but if you can choose the option that best lines up with how you're feeling about these proposals, please do. Okay, some quite interesting results actually. So we've got sort of in joint top, people saying that the changes, having these exceptions in place, allowing for quicker settlement is a good move, but that these changes shouldn't apply retroactively to people who are already in the UK. And also people saying that it's too complex. So perhaps it's good that there are exceptions being put in place, but they're too complicated at the moment. There's too many things to consider and people won't understand when they're entitled to settle. We've also got some people saying that they think that the changes are sensible generally and that they're well thought through, and a few saying that they're terrible. So a lot of mixed views on these, and I expect as we get more detail, that'll shape opinions further. Looking ahead, the Home Affairs Committee have launched an inquiry into the proposed changes to ILR with the purpose of evaluating their potential impact. Now, as part of this inquiry, the committee have put out a call for evidence, giving businesses and employers the opportunity to make written submissions on how these changes are likely to affect them. And organisations have until the 2nd of December 2025 to submit their evidence to the Home Affairs Committee. And the Home Office themselves have now also started a consultation process on how the changes will be implemented, and that will run until the 12th of February 2026. So we would encourage you to engage with these processes if these changes are likely to impact your business, and if you've got any thoughts on how the proposals are being put in place. Clearly from our poll, there are some quite strong views already. Now, judging by how quickly this government have implemented previous immigration changes, such as those to salary requirements and skill levels from earlier this year, we expect that the changes to ILR will be brought into force shortly after this February date, so perhaps sometime in March or April 2026. Now, as mentioned earlier, everyone who has not already settled by the time these rules come into force is expected to be subject to the new rules. That's what the proposals say at the moment. It's perhaps worth briefly touching on the proposed approach of some of the other political parties. So Reform UK, who currently lead most general election polls, have said that they would abolish ILR entirely, not only preventing anyone from qualifying for settlement, but also rescinding permanent residence from those who already have it. An ILR would be replaced with a new visa requiring renewal every 5 years, with higher English language standards and stricter requirements on bringing family. And supposedly, this visa would also be subject to a minimum salary threshold of £60,000 per year. The Conservatives' Shadow Home Office Minister, Katie Lamb, has said that the Conservatives would similarly abolish ILR and revoke permanent residence from those who already have it once the UK leaves the European Convention on Human Rights. But Kemi Badenoch has since clarified that Ms Lamb misspoke on these points. So the Conservatives' policy in this area remains somewhat unclear, but it is likely that they would adopt a stance falling somewhere between that of the current Labour government and Reform UK. And the Green Party have surged in the polls since the election of Zach Polanski as their new leader, and some recent polling has even shown them finishing in second place, ahead of both Labour and the Conservatives. And their policy on ILR is to have a universal 5-year qualifying period, which would apply across the board to all routes. Moving on from indefinite leave to remain now, although I expect we'll have some questions later on, it's also worth highlighting the latest proposals for right to work. Under the current regime, employers need to carry out a valid right to work check to protect themselves from illegal working penalties. Now, there are currently 3 types of check, which are each appropriate in different circumstances. These are manual right to work checks, which are ordinarily appropriate for British and Irish citizens, though they're also available in some other niche circumstances. Home Office online right to work checks for non-British and non-Irish citizens, so ordinarily someone with a visa or indefinite leave to remain, or a check using a digital verification service, which is currently only available for British and Irish nationals. Now, as Imelda touched on earlier, there are big issues with non-compliance in right to work checks at the moment, resulting in high levels of illegal working. Now, some of this may be down to unscrupulous employers who are choosing not to carry out checks and instead deliberately employ illegal workers. But the complexity of the current regime, with 3 different types of check and myriad other factors to consider, is likely to also be contributing to right to work checks not being done or being carried out incorrectly. And the government have now launched a consultation on further expanding the scope of right to work checks to also cover businesses hiring gig economy and 0-hour workers to try and tackle illegal working in the hospitality, delivery and construction sectors in particular. This consultation is open until the 10th of December 2025, so if expanding the scope of right to work to cover more casual forms of work is likely to affect your business, we would encourage you to respond to the consultation before then. Earlier this year, the government announced their plans to introduce a digital ID by 2029. Now, that news caused concern in some quarters, with worries over what this digital ID might entail. And the government have since come out and clarified that the digital ID will only be mandatory as part of the new right to work regime, with employers being required to check digital ID when someone starts working for them. Now, the hope is that standardizing right to work checks in this way will reduce the complexity associated with carrying out checks and thereby limit the scope of what can go wrong. Now, will this work in practice? Well, unfortunately, even with a simplified and standardized process, the risk remains that some employers will not carry out right to work checks, either because they forget to do so, or do not realize that they have to carry out checks, or because they deliberately do not check right to work in order to employ illegal workers. I'm now going to hand back over to Imelda to speak about the new travel authorisations affecting the UK and Schengen area.
Thank you very much, Callum. That's a lot to digest, I have to say. Okay, so the Electronic Travel Authorisation, or ETA as it's been known, has been operational since 2025. It applies to all European nationals and other non-UK nationals who visit the UK. It costs £16 for a 2-year authorisation. It is similar to the US ESTA and the scheme which will come into operation for Europe called the ETIAS. Now, the purpose is pre-travel security screening for visa-free visitors to the UK. So those who used to pass through entry gates, such as US, Australian and European nationals, will now need to apply for an ETA before they travel to the UK. Now, despite this being operational since April 2025, it has not been rigorously enforced. But we are now told that from the 25th of February 2026, All visitors from the 85 countries, including US, Canada, Australia, and EU countries, must have an ETA in place in order to travel to the UK. Now, the EES, or the Entry-Exit System, is a digital recording of entries and exits to the Schengen zone, which consists of 29 countries, both EU and non-EU countries. Now, this launched earlier this year on the 12th of October under a phased rollout, and we are told it will be fully operational by the 10th of April 2026. And this was planned 2 years ago, but there have been numerous delays with the capturing of digital data. And considering it spans 29 countries, these countries need to be aligned. So despite the intended operation by April 2026, we're not quite sure if the countries will be able to meet that deadline. Again, the purpose of the EES Entry-Exit System is automates border checks for non-EU and non-Schengen travellers, which includes UK nationals. It replaces manual passport stamping. It collects biometrics, that's fingerprints and facial image on first entry. So any who have travelled to Europe since April may already have encountered these changes on entry. And most importantly, it tracks entries and exits to enforce the Schengen 90 in 180-day entry rule. There are some exemptions for long-stay visa holders, legal residents of the EU, etc., and for children under 12. This data is retained for 3 years from the last trip. So it's really important if you are travelling frequently, either for business or for holidays, that you do comply with the rule 90 in 180 days within any of the Schengen countries. Of course, there has been an impact in Dover, the Eurostar Eurotunnel, where individuals now probably have to leave their vehicle to go to the kiosk to deliver their biometric information. But as I said, once each country starts to implement it, it should become a little bit more efficient. Now, once the entry-exit system is in place, the Schengen zone will operate a similar scheme to the ETA called the European Travel Information and Authorised System. So again, it's similar to the ETA or the ESTA for the US. This will be launched once they have sufficient data from the entry-exit system for about 6 months. So it needs to ensure the data is calculated and it's accurate across all of the Schengen zone countries. It will apply to citizens of visa-waiver countries, so UK nationals will be impacted, but it will not impact travel to Ireland, even though it is part of the European Union. The process to apply, similar to the ETA or ESTA, you can apply in a mobile app. There are checks undertaken against certain EU databases, and the fee is slightly less, which is €20 for 3 years, or the passport validity, whichever ends sooner. There are exemptions to European nationals who have withdrawal agreement rights under the European Withdrawal Agreement and holders of EU residence permits. So we should expect to see that by the end of next year. Just to mention the Common Travel Area, which applies to travel between the United Kingdom and Ireland. This will be maintained, and it's separate from the Schengen Agreement. So Ireland will not implement the EES or the ETIAS, and Irish passport holders, will be exempt from travelling to the EU and the Schengen countries. Now let's move on to another poll. This is just to reiterate the information I just shared with you. So how many days are British citizens allowed to stay in the Schengen zone? Is it 6 months? Is it 90 days in any 180 days? Or is it unlimited? I'll give you a moment to answer. Wonderful. Thank you all for listening. So yeah, it is really important when you're traveling for business or in fact for holidays to just keep an eye on the number of days you're spending in the Schengen once the EES and the ETIS are operational. Now I'm going to move on to my final topic, which is to look at the new sponsorship portal. So the Home Office developed a new sponsorship system called Sponsor UK System, short for SUPS. Now, this was rolled out for testing to a small number of sponsors with temporary licenses earlier this year. However, the beta was abandoned about 3 weeks ago, much to our disappointment, I understand. We don't have the full details as to why it was withdrawn, but the Home Office have now said they will focus on enhancing the current SMS system, which has been around since 2007. So some of us are quite disappointed that they will continue to maintain a system as old as this, but we just need to wait and see what enhancements they can make in the next couple of years. So what's new with the current SMS? The next phase is to introduce a multi-factor authentication for sponsorship management system users. Level 1 users are being asked to provide a mobile number when they log into the portal. So the MFA has been introduced to enhance the sponsor account security. It does add an extra layer of protection by requiring users to verify their identity using 2 or more methods, not just a password for logging in. So on the 11th of November, the Home Office launched a private beta with 40 premium sponsors to test this new functionality. So all level 1 users will now need a mobile number to log into the sponsorship management system, and this will be captured when the MFA is initially set. Level 1 users, it's important that level 1 users keep their mobile number up to date, and their date of birth is also up to date, as this will be the secondary source of validation. And now a step-by-step MFA user guide was shared with sponsors participating in the private beta. So we expect this to be shared with wider sponsors once it's been formally introduced. So the timescales, well, we expect to see incremental changes, as we've always seen with the current system, with very little notice, unfortunately. But they're saying it will take about 2 years before we see the functionality that was originally promised with the SUK system, which was about 10 years in development. So I think that's a pretty exceptional estimate, given the SUK system is 10 years in operation, but we'll see. So that concludes what I have to say. I want to hand you back to Callum to discuss what we expect will lie ahead for 2026 and beyond. And then we'll have some questions. Over to you, Callum.
Thanks, Imelda. So what does the future of immigration look like? Well, we can expect the Home Office's compliance crackdown to continue, with rejections, refusals and revocations of sponsor licenses becoming increasingly common as the Home Office look for any technical breach as an excuse. We can also expect increased compliance action being taken on right to work, with fines and arrests at the levels we've seen over the last year or even higher, particularly with the expanding scope of right to work to cover more casual forms of work. There have already been and will continue to be changes affecting visas, from salary requirements and eligible roles to English language standards and increases to the skills charge. It's worth being alert to when these changes are coming into force and timing certificates of sponsorship and visa applications accordingly. And of course, the indefinite leave to remain proposals represent a significant change in this area, with a new standard qualifying period of 10 years, applying retroactively to those who are already in the UK. Now, while the new rules remain subject to consultation, it is clear that there will be far more complexity and many more factors to consider when planning a path to settlement, with individuals and employers needing to consider whether there are any applicable extensions that they can take advantage of to reduce their qualifying period. And digital ID promises to simplify the right to work regime in due course, but in the meantime, there is that consultation that employers can feed into on the expanding scope of right to work. We have one final poll to leave you with now, similar to the previous one, but wanted to get a sense of how everyone is feeling about the immigration policy changes that we've discussed today. So do you think that things are moving in the right direction? The changes seem generally quite sensible. Do you think that some changes needed, but the higher costs and the reduced labour supply, it's all going to have a negative impact on businesses? Do you think the changes go a bit too far, particularly in certain areas, and that they're unfair on individuals in particular? Or do you think that the changes are mostly awful? Are you pretty down on what we've discussed today? So give you a moment to give your thoughts on that. And as I said, similar to the earlier one, I understand that your views might not entirely align with any of these options, but if you can pick the one that you think best fits how you're feeling, I think it'd be quite interesting. Okay, so again, quite mixed results. So that the leading option is that the changes go a bit too far and they're unfair on individuals. And I do think that this is something that, you know, particularly the discussions that I've had with people recently, this idea of the indefinite leave to remain changes applying retroactively to people who are already in the UK, already on the route to settlement, does seem quite unfair. Of course, as part of that consultation, there will be the opportunity for both organisations and individuals to give their thoughts on that proposal and to suggest perhaps that there should be some transitional provisions put in place. But there are also quite a few people saying that yes, change is needed, but the impact of higher costs, so higher salary levels, higher immigration skills charge, etc., is going to have a negative impact on businesses. So thank you for attending today's talk. We're now going to hold a quick Q&A session to answer any questions that you might have. So I think we already have a few, Imelda. Unfortunately, I think they're both for me, so none for you at the moment, but
Yeah.
let me just pull these up. So one question that we've got here is, do these indefinite leave to remain changes also apply to those who are already on a spouse visa in the UK of a settled person, so not a British citizen? My reading of the proposals is that these changes would apply to such a person. Now, it is something that as part of that consultation, they are seeking people's views on. And so if that's likely to affect you or people that you know, I would encourage you to respond to that consultation, because it is something that I think the Home Office can expect to get significant pushback on, this retroactive application of the rules to people who are already in the UK, already on the route to settlement. So, but as I say, my reading of the consultation statement at the moment is yes, these changes will apply to somebody who is a spouse on a spouse visa and is a spouse of somebody who is settled in the UK. To be clear, not somebody who's settled on the EU settlement scheme. Those people are not affected by the changes. Another question we've got here is about the ILR changes again, that they're under consultation, asking, you know, when's this consultation going to end and when do we expect to have the new law in place? So as I mentioned, the consultation is ending in February, the Home Office consultation. The call for evidence from the Home Affairs Committee is ending a little bit earlier in December, but the consultation ends in February. And as I said, because of what we've seen with salary level changes, skill level changes, this government, at least on immigration changes, has actually been quite quick to implement these changes. So they'll propose something and then a couple of weeks later it's in force. So my expectation, and there's nothing sort of saying this for certain in the consultation statement, but my expectation is once that consultation is concluded, so on the 12th of February, they'll review what's come in, and I expect that we'll then get an announcement probably a couple of weeks later saying what they're going to put in place. And I wouldn't expect there to be a very long sort of period of time between that statement coming out and those changes actually being brought into force. So that's why I said I'm expecting it to be March or April 2026. It could be later, it could be significantly later, particularly if the responses to the consultation are sort of very anti the proposals and particularly asking for transitional provisions, then it may be that they delay it until later in 2026. But my expectation at the moment is that it'd be March or April 2026.
Can I just add one thing to that, Callum? I think it's important to note that if an application has been submitted for indefinite leave to remain within one of the eligibility criteria dates, which could be from the date your application was submitted, the date the visa decision was received, or any time up to 28 days before the end of your continuous residence period. If an application has actually been submitted, it's very unlikely that the Home Office would apply the new rule between the time of your application submission to decision.
Yeah, and just building on that, Imelda, because obviously that is, as it stands, that is very much how it works, that if you get your application in, the rules as at the time that you put your application in will apply. My sort of one word of caution on that here is that I'm just looking at the consultation statement, the wording that it uses, and this may just be poorly worded by whoever wrote it, but the wording that it uses is that it says, without any transitional arrangements, the earned settlement policy will affect people already in the system who are not already settled when the relevant immigration rules come into force. So it doesn't say, who have not already put their application in, it says who have not already settled. Now, as I say, and as Imelda said, as it stands, if you put an application in, the rules at the time that you put the application in apply. But this wording is causing me some slight concern. It may just be someone's worded it poorly, and that's not what they mean at all. But again, it's something where I'd really urge people, if you're going to be affected, if your employees are going to be affected, contribute to these consultations, contribute to the call for evidence, because you can help shape the policy on this and make sure that it is perhaps a little bit fairer than how it's looking at the moment. What other questions have we got? We've got one here, Imelda. I might give this one to you in the first instance. So what can we do to prepare our current sponsored employees?
Sure. Well, you can have a look at where they are in their continuous residence period. The current rules say 5 years, which can be calculated from one of 3 dates. Assess where they sit at the moment, and if they're eligible up to 28 days before one of those dates, then support them with making an application if they're sponsored. Employers usually need to support with a letter for their application in any event. So perhaps undertake an audit, find out when they started. It may require asking for additional information from the individual if they've perhaps switched from another skilled worker visa or another eligible visa, which will count towards the visa you're currently sponsoring. But yeah, ask your individual employees and provide any support you can.
Yeah. And we've had a few people, Imelda, actually asking for links to the consultation and the call for evidence. So yeah, we'll circulate that after. We'll circulate those. Sorry, after this webinar's finished up. Yeah, and it's all online. There's nothing too complicated, hopefully. So, but if you do have any questions on either the call for evidence or the consultation, please do get in touch with us. We'd be very happy to help you with preparing your responses or answering any questions. I did note that one of the questions in the Home Office consultation on the indefinite leave to remain changes is worded quite trickily. I'll see if I can find that in a little bit, but essentially it's a double negative. So you do need to be a little bit careful in answering these questions, because it might just be poorly drafted. It may be the Home Office trying to catch people out and get the responses that they want. Difficult to know. But yeah, if you do have any questions on either the call for evidence or the consultation, please do get in touch. But we will circulate the links after we're finished with this webinar. And we've had another question asking, would it affect anyone on a visa already, regardless of if they're sponsored or not, depending on their salary? So yes, it's affecting everyone who's on a visa at the moment. There are some exceptions, as we discussed. So people who are spouses of British citizens or family members of British citizens, people on the global talent visa. There was another one that's escaping me at the moment, but there are. Yeah, European settlement scheme as well. So there are a few exceptions, but yeah, generally the general rule is that this earned settlement policy is going to apply across the board, with those minor exceptions. I think that's it on the questions, unless I'm missing any. Yeah, but as Imelda mentioned earlier, if you do have any further questions, please feel free to get in touch, and we'll come back to you on those. But I'll hand over to you, Imelda, to finish us up.
Sure. Well, I'd like to thank you all for joining us today, and especially for participating in our polls. They're a great way of getting your views on how you think things are going. If you need any further information, our contact details are on the slide. Please also connect with us on LinkedIn. We share regular content and comments and just sharing our views really on some of the proposed changes and immigration. And one other thing, please, if you would stay online to complete our feedback form, it will automatically appear on your screen once the session closes. You'll have the chance to win £15 John Lewis voucher as well. And maybe give us a little bit of feedback on the content, the topic, and the style of the presentation. So from the immigration team here at Fields, Field and Parks, wishing you a wonderful rest of the week, and a little bit later, a wonderful festival season. Thank you very much. Thanks, Callum.